Welcome to the DisabiliTEA, a podcast where we have candid discussions about all things related to disability. Short-term, long-term, financial claims, impact on other areas of life, causes in the workplace, and more. With your host, attorney Anjel Burgess. You can find this show at www.disabilityhelpline.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. Now here's the host of the DisabiliTEA, Anjel Burgess.
Good afternoon and welcome to the DisabiliTEA. Today we are pleased to have with us attorney Sandy Burney, who is a family law attorney located here in Georgia. Welcome, Sandy.
Hello. Thanks for having me. Glad to be here.
Well, we are so excited to talk with you today. I've got so many pressing issues that I want to ask you about as it relates to family law. But before we jump in, if you want to just share with the audience a little bit about you and your practice.
Absolutely. So I am primarily a family law attorney. I've been practicing for about, difficult to say, 16 years. So primarily it's family law, but I deal with all things family related. So that would be divorce, child custody, child support issues, as well as I do a lot of adult probate court and guardianship. So a lot of disability type related issues.
Well, that's wonderful because I get a lot of calls from clients who are having family law issues. So I'm glad that you're here today so that you can help us to better understand some of the challenges that individuals can see or meet if they are disabled and they are dealing with any sort of family law issue.
All right.
So my first question for you is about divorce and how a divorce can impact someone who is disabled and unable to work. I am sure that there are some potential implications. Can you share any with us?
Absolutely. So first, let me say this. Divorce is a challenge, whether it's contested or uncontested. So even when the parties are getting along and everything is great, it's still a challenge and it's a transition. That's probably a better word. It's a transition for everyone because you're going from possibly a two-income household, or this how things used to be, to now things look totally different. And if there are children included, then it's also a transition for the child. So some of the things that you may want to consider are, for example, health insurance. Typically, there is, one spouse or the other that carries health insurance for the whole family. So what does that look like if you have a person who is disabled and going through a divorce? Maybe there needs to be a provision made in the divorce agreement for the carrying spouse to continue to provide that insurance for a certain period of time. Because as you may know, once you get divorced, there's a window in which you have to notify your health insurer administrator or whoever handles that. They have to be notified within a certain window when there's a change of what they call a life status change. So that means you get married, you get divorced, you have a child. You really have a certain window to report that. And so that comes up a lot, and that may be something that the parties may want to contemplate when going through a divorce.
So you mentioned uncontested and contested divorces. Can you explain the difference?
Yes, well, everyone always comes to me and they say it's going to be an uncontested divorce. And uncontested essentially means that the parties have agreed on all of the issues. And so there's nothing really left for the court to do other than to just kind of look at everything as a formality and award the divorce. More often than not, that's not the case. It's usually contested. So, for example, if a couple is going through a divorce and they have children, the court is going to be looking to resolve things like marital property. marital debt, custody, child support, alimony. Those are the 5 categories that have to be resolved. And so if it's uncontested, that means these parties have sat down, they have worked out all of those issues, and there's really nothing for the court to do. They've executed a settlement agreement, everything has been filed with the court, nothing else to do. That's a truly uncontested divorce. Now, contested could mean not necessarily that the parties don't agree on all of those areas. They may have worked out 1 area, 2 areas, and then there may be 2 or 3 that still need help.
So in your experience, have you seen instances where parties have come to an agreement, and let's say that there are no children involved, right? Mm-hmm. But the parties have come to an agreement and they've said, okay, we're going to get divorced. We're going to split up the assets. We are going to, split the debt. And that's it. In situations where one of the parties is disabled, mm-hmm. is it generally a good idea to agree to an uncontested divorce?
I would say no.
Okay.
And I always say, even if the party is disabled or not disabled, it's always a good idea to seek at least a consultation with a professional attorney, right? Because you want to be fully aware and fully understand what it is you're agreeing to, what you're agreeing to do, what you're giving up, because what most people may not know is once that court issues a divorce decree, it can't be modified. So you don't get to go back later and say, oh, but I didn't know that he had or she had, I don't know, $10 million in the bank, and I was entitled to that. You can't, it's non-modifiable.
Wow. Okay.
So there are some things that can be modified, things like alimony, things like child support, mm-hmm. things like child custody. Mm-hmm. But property division is not one that can be modified.
Okay.
So that's important. And so I always say it makes sense just to spend a few minutes with a professional, understand what you're agreeing to, understand what you're getting, but also understand what you may be giving up potentially.
Okay. So that holds true regardless as to whether one of the parties has a disability. So
absolutely.
Just that out.
Absolutely.
Seek a consultation, know what your rights are, make sure that you have an adequate understanding of the big picture as it relates to marital property, assets, all debts, all of those things.
Absolutely. Okay. 1000%. Yes.
And is it true that the court, like if you do an uncontested divorce, is it true that the court is not interested in trying to figure out if there are any issues out there or any rights that either party is giving up?
That's correct. The presumption is that the parties understand, right? Because there is a document that contains both parties' signatures that basically says, I understand what's going on. I'm giving up everything, or I'm getting this, and we've resolved, because that document is going to say that you have resolved all issues. Now, the court will review it for formality to make sure all the I's are dotted, T's are crossed, all of the necessary documents are there. But other than that, they're not going to investigate, right, whether there's some other asset that hasn't been disclosed, whether, a party may be disabled. What are they going to do about insurance? The presumption is that's already been covered.
Okay. All right. Well, that's really good to know, because I do get a good number of clients who, in most cases, have already been found disabled. We've already helped them to get their benefits, and then they call me later on and say, well, my spouse and I have decided to get divorced. And sometimes it's we've already gotten divorced. We did an uncontested divorce, and other times it's we're in the process of. Mm-hmm. So it's good to know that everyone should have a consultation with an attorney, regardless of the circumstances, before any sort of agreement is entered into.
Absolutely. And I can't tell you how many times I get phone calls of people who did not do that. And they thought one thing was taking place and it didn't happen that way. And they're divorced. And I have to give them the news. Unfortunately, that's something that can't be modified.
Okay. All right. Well, you heard it here first, folks. So make sure that you take care of that and get your consultation. So I want to move on to a related topic that you've already mentioned, and that is related to custody.
Mm-hmm.
I do have a number of clients who themselves are disabled, they have children, their spouse is not disabled, but they are getting divorced.
Mm-hmm.
So my question to you is, does a disability kind of status have any negative impact in a child custody case?
It depends.
Okay.
It could, right? So when it comes to child custody, the thing that the courts are going to be looking at and the judge is going to be looking at is the best interest of the child, right? That's the standard. That's the gold standard. That's the only thing that should be taking place. So what exactly does that mean? If you have a mom and dad that are getting divorced, obviously mom may think it's in the best interest to do X and dad may think it's the best interest to do Y. So with that in mind, the court could use what's called a guardian ad litem to help the judge make a decision when it comes to the best interest factors, right? And there are 17 factors that the court looks at. 17 of them. Now I know we don't have time to go through all 17 today, but I just want to touch on some of them just so your audience can have an idea of what the court would be looking at.
Great.
The love, affection, and bond and emotional ties that each parent has with the child is going to be looked at. That's one of the factors. The bond and the connection that the child may have or may share with siblings, step siblings, right? That comes into play all the time with blended families.
Okay.
And so there are half siblings, step siblings. How well each parent knows the child's needs, how they respond to those needs. Sometimes you have one parent who may be, the primary breadwinner and works most of the time. And let's say the non-working parent is fully in tune and fully engaged to what the child needs. Favorite colors, how well he or she is doing in school. Doesn't mean that the working parent doesn't know. That's just a sacrifice that family has made so that they can, do certain things.
Right.
And so this particular factor is the one that gets to the root of what we're talking about today. And that is the mental and physical health of each parent.
Okay.
That's one of the factors, one of those 17. So what each parent has mentally or physically, and more importantly, how does that affect his or her ability to parent?
Okay.
Right? Because you could have a disability and it not affect your ability to be a parent at all.
Right.
You could have a disability and you require some additional support or some additional assistance, right? Outside services, family support. I've had several cases where, disabled parents were still able to have joint custody, they work, all sorts of things.
Okay.
So, and that's where the guardian ad litem could be critical, not just in a custody case, but particularly if a disability comes up and is concerning, because one of the things that the other party, the non-disabled parent, may be saying is, Sandy has a disability and can't be a full-time mom.
Right.
right? And so the judge doesn't have any way of knowing that. That's where a guardian comes in. And I'd always educate my clients and say, okay, you have a disability. So what? Tell me what your limitations are, if any. Right? And so that's just a few of the factors that the courts are going to be looking at.
Okay, so there is no kind of blanket rule that, if one parent is disabled, that parent is going to lose custody of the children because they have been found to be disabled.
Absolutely not. Absolutely not. It's going to be based on a case-by-case circumstance. Again, how does that disability impact mom or dad's ability to parent the child and to provide care? Despite that disability, what sort of assistance will the parent need for him or herself in addition to the child? Those are things that, if someone has a disability, you're going to want to know those types of things.
So if the child or children are a little older, let's say we've got teenagers or kind of young teenagers, somewhere in that 12 on up range, and the child or children is instrumental in maybe helping out because the parent has a disability and maybe has difficulties doing things like standing up to cook or to clean, and the child is instrumental in helping with that. Does that in and of itself mean that the disabled parent is not able to parent effectively?
It doesn't. Okay. Again, we go back to, it's very case driven, the particular facts of this case. It depends on, again, what the disability is. So on the one hand, you could say, okay, I have party A has an older child. Obviously, a child that's 12 or 13 or 14 or 15 doesn't need as much assistance as a 2 or 3 or 4-year-old.
Right.
Okay. And so they're pretty independent, self-sufficient. They can feed themselves to a degree. They can dress themselves. They may be able to get to school without assistance, right? If they live in an area where they can just walk to the bus stop and take the bus.
Right.
That's when the court may start to look at, well, what is the disability? Okay, because that may make a difference. Is it a physical disability or is it a mental disability? And the court will want to inquire a little bit more about that. Okay. Is it a disability that, for example, let me think of a good one. Let's say it's a mental disability.
Okay.
And let's say, one of the things that the court may want to know is, okay, what is this disability? Does it require medication?
Right.
Is it going to create a potentially dangerous or life-threatening environment, right, that is going to put the child in the situation of having to respond? Okay. So those are the types of things that, you would want to, as attorneys, we kind of flush out and get to the root of all that, see how it impacts the child. What type of assistance does the parent need? I've had clients that have been wheelchair bound. Did not affect their ability to parent, go on to get joint custody.
Okay. All right. Well, that's good to know, and that's helpful to know because I know that a lot of the parents that have the disabilities are afraid, and they are afraid that being found disabled, or that if they're already receiving disability, that spouse will come in and say, I'm taking the kids, not fit. And they think that automatically, because they're disabled, that they are not going to be able to have joint custody. So that's great to know. Again, sounds like a situation where legal advice and counsel is critical.
Absolutely. You always want to consult with a professional. The biggest takeaway from all of this is remember that there's a lot of discretion in this area, right? And so you have judges who are people making these decisions after hearing this evidence and learning more through a guardian ad litem. Okay. So because it's such a huge discretionary piece involved in this final decision, you want to consult a professional to figure out, okay, what do I need to do to demonstrate my ability to be a parent, in a safe environment? What types of things might I want to do? Maybe I want to show my involvement with the school. The child is in the 6th or 7th grade, even though the parent with the disability might be the parent that's at the school for all of the PTA conferences, or, if the child gets in trouble or is injured at school, that might be the parent that gets called. Okay. Those are the types of things that you want to show. Hey, judge, I've been doing this stuff already. Maybe the disabled parent can't drive. Okay, so how do you get around that? Maybe that parent takes an Uber. Maybe that parent has an aide that comes in and helps the disabled parent drive to the doctor, get to the grocery store, get to the school. All of those are perfectly acceptable things. There's nothing wrong with that at all.
All right. Well, that's something that, we just wouldn't know without seeking the expertise of an attorney. It's just not something that you would think would be, appropriate. So that's refreshing for me to hear, and I'm sure it will be for others as well.
Just a lot of discretion, and it's just the thing that your audience should just be aware, talk to a professional. And there is no cookie cutter. So you may know somebody else who had a situation and this how theirs was. Yours may not turn out to be that way at all.
Okay. All right. So highly individualized process.
Yes.
Now, the last kind of area that I want to just touch on is related to child support obligations. So if a disabled parent is also getting money for their child or children through Social Security disability, and does that parent get like a credit as it relates to child support?
So it depends. If the disabled, ask your question again, if the disabled parent is also receiving child support.
So let's say that
Are they divorced at this point, or?
So let's say they're going through a divorce, right? And the parent, the disabled parent has been deemed disabled by Social Security. And because that parent is disabled, there is also a monthly check that goes to the child. The child, correct. Yes. When it comes to the divorce and the need for any child support, and the money that the child gets from the disabled parent kind of count towards that disabled parent's obligation, if any, to pay child support?
Yes, there will be a credit if the disabled parent is the parent paying child support. Okay. And I'll give you an example. I had a client. It was a non-marital situation. But he was receiving Social Security disability, had a child under the majority. So the child was at the time, 8, 9, 10 years old. Okay. And so when it came to factoring in child support, the amount that the child was receiving was credited against his total child support obligation. Okay. However, you might have a situation where the child support obligation might be less than right? What the child is receiving. So let me just give you an example. Let's say the total child support is $300 a month. But let's say the check that the child is receiving through that disability is $500 a month.
Okay.
So in that case, there would not be an additional child support obligation.
I see.
But if you flip it, and let's say the child support was $500, but the benefit was $300, then you have a $200 difference.
Okay.
Which that parent would have to make up that difference. Yes.
Okay. All
Does
right.
that make sense?
It does. It does. And that's also helpful to know that there can be a credit if there are additional benefits available to any minor children.
Yes. And one other thing I would probably say is that the disabled parent should also think about benefits that the child may or may not be able to qualify for based on disability. And so that comes up occasionally, not a lot, but it does come up a little bit as well.
Okay. All right. Are there any other pointers, tips that you would like to share with the audience as it relates to, disability and hopefully kind of preemptively taking steps, when it relates to a divorce case or a child custody case, any additional steps beyond what you shared that it would be great if the parent with a disability took before actually going through the divorce process?
I would say first and foremost, always try to be proactive. So most times by the time people come to me and say, hey, I'm getting a divorce, there's already been some discussion. There may have been a separation, things of that nature going on. So try to be proactive and not reactive.
Okay.
So if it's a certain circumstance that's going on where the parties have been talking about a divorce, but maybe haven't made a final decision, that might be a great time to consult an attorney to say, hey, we're just talking about it. What do I need to start thinking about? Right. And at that point, you start going through the specifics of what your particular dynamic is, right? With kids, without kids, short-term marriage, 2 or 3 years versus 30-year marriage. Right. Those types of things make a difference in the outcome and what's going to happen. So I would say try to be proactive. That's really the biggest thing. Get that consultation. Understand what's going on, what you're going to be agreeing to, what you're going to be giving up. Those would probably be my biggest 2 takeaways. Okay. And then understand that everything is not cookie cutter. There is no presumption that the non-disabled parent or that the mother, right, is always going to have custody. Things are changing. Okay. Fathers are getting custody. Okay. Disabled parents are getting custody. And so things are changing. There's no presumption anymore that, based on gender, based on economics, those things are going to be an automatic when it comes to a divorce or when it comes to custody.
Okay.
Okay.
Well, thank you so much. Wow, you shared so much great information. How can our audience reach you for a consultation or for any questions?
Absolutely. First, they can go to my website, which is www.burneylaw.net. That's B as in Bob, URNEY, law.net. And my office number is 404-480-4106. And I would love to hear from any of them. Happy to answer any questions and kind of, walk them through the process and hopefully make it a little easier, because again, it's a transition. It's very stressful. Fear of the unknown is going on, right? I don't know what this process is. How long is this process going to take? What am I going to have to do and things of that nature? So hopefully me or I can help alleviate some of those concerns.
Absolutely. Well, thank you so much, Attorney Sandy Burney, for sharing with us tools and tricks, tips, and everything that a person would need to know and to think about if divorce seems like it's on the horizon. It's important to be as proactive as possible. Reach out to Attorney Burney with any questions. Get a consultation and allow her to help you figure out what the best steps for you will be as you move forward.
Thank you so much for having me.
Thank you so much, Attorney Burney. This has been another episode of the DisabiliTEA. We thank you for joining us, and we look forward to talking with you next time.
You've been listening to the DisabiliTEA with Anjel Burgess. Thank you for your positive reviews, comments, and sharing the show with others. You can catch prior episodes at www.disabilityhelpline.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more.